All right, there we go. We are going to be going over the listing agreement for GCAAR. And this covers um, any sort of real property, so anything with a house on it, and also co-ops or cooperatives. So the thing to remember is with co-ops, you're buying shares of stock in a housing corporation. So you own real estate, but you kind of sort of don't, if that makes any sense whatsoever. You own stock in order which to live in the building. Let me just get my tools here and we are ready to go. All right. So just like with any listing agreement, we're going to start out with an address. We're going to call it 123, excuse me, 123 Magnolia Street Northwest. If it's in a condo building or such, we would put the unit in here, condo or co-op, etc. The subdivision, again, you can find that usually on tax records. If it's a certain project, you would again put that in here. Same thing, city, state, zip. And before we continue, let me discuss GCAR. GCAR is the Greater Capital Area Association of Realtors. And we use these forms for, as it says at the top here, Montgomery County, Maryland, and Washington, D.C. So if you're in Montgomery County and D.C., this is the listing agreement you would use. Otherwise, if you're anywhere else in Maryland, you would be using the MAR contracts. So as we continue, we would put the lot number, the block, and the tax ID. All of that is going to be found on the tax card, which you can pull up in Bright. One of the things to remember when we're listing a property, especially in Maryland and DC, there might be parking spaces. So we need to make sure that we have the space numbers. And again, when we're in buildings, condo buildings, co-op buildings, there might be a storage unit. And both of these things generally convey with the property. When the seller is selling the condo unit, if it's coming with a parking space, that's generally included, as is the storage unit. They're generally not sold separately, but they can be. I don't know why they wouldn't be, but everyone's different. Um, I know of a situation a couple of years ago where the property was in Virginia, and um, the owner wanted to sell the storage unit separately, and the buyer agent wrote it into the contract. Listing agent didn't catch it, the seller didn't catch it, and as they were going to settlement, they realized that storage unit was included in the price, and the seller wanted more money, but it was already agreed on. So again, it's important to make sure that we have the parking spaces and the storage units that are going to be coming with the unit. We would put the seller's names in here. If they're in command, they will autofill. So we're going to use our friend Joe Smith as the seller. And if there's a second seller, again, we would put their name, a third seller, etc. Remember, if you put it in command, the address will autofill for you. So usually it's probably going to be the same. So 123 Magnolia Street, Northwest. I will do Montgomery. Let's call it Bethesda. Maryland, and we'll just do 1, 2, 3, 4, 5. And then again, that will autofill. If the seller has an office number, home phone, you can see there are two lines for cell phones. Same thing for email addresses. Now we're working on it. Um, the listing office should uh, automatically populate here. So Keller Williams Realty Alliance Group Reston should populate. We would put in our broker code depending what office you're in. If I'm in Reston's KWR 8. The address is populating. We need them to add suite 710. Again, office name, listing broker or supervising manager name. Um, in Reston, that's Doris Led. Better. Then listing agent name, your license number, either in Maryland or DC, cell phone, direct line, etc. So every agreement has to have a purpose. So, and when we create a listing agreement, a buyer agency agreement, it's a brokerage relationship. And that is, like it says here, an agency relationship between a seller and listing broker, and a contractual obligation between a seller and a listing broker, in which the listing broker has the exclusive right to sell, exchange, or convey the herein described property, together with all improvements, rights, and easements thereon and under the terms set forth herein. I know that's a little bit of legalese. Basically, what it means is the seller is giving the listing broker permission to sell the property and sell, exchange, or convey the property noted above, and again, that storage unit, those parking spaces, etc. Number 4 is the list price. It is being offered for sale at whatever price the seller wants. Let's say this is going to be listed at $850. That would go in here. And notice the rest of the line. Or such other price as is later agreed upon by seller in writing. So remember, all changes to the listing agreement or any agreement need to be in writing, and it needs to be signed by both parties, the listing broker and the seller. So broker and seller both need to agree. Number 5, listing period. So it starts when it's signed. So if that's today, again, it starts when it signs and expires at 11:59 on a certain date. Again, this can be whatever date you and your seller agree on. For example, I just put December 31st. Remember, if you're changing it, need to get it in writing. Like with any other contracts, if a sales contract is ratified before the agreement expires, providing settlement beyond the listing period, it automatically extends until final disposition of the sales contract. What does that mean? That means um, you go under contract on December 25th, you're closing February 1st of 2027. This contract automatically extends until closing on, what I say, February 1st? Paragraph 6, entry into Bright MLS. Property information submitted into the MLS describes the price, terms, and conditions under which the seller's property is offered for sale. All listings must be entered into Bright within 2 days of the execution of this agreement, unless property is not ready for public marketing and option 1, pre-marketing status, is selected under status of property below. The listing term is defined by Bright MLS as the first date any potential buyer may learn about the property. So the key things to remember: all listings need to be in Bright within 2 days of the execution of this agreement, unless the seller agrees to in the next section of the listing, such as a pre-marketing status. So down here, if option 1 is selected below, enter the date property will be entered into Bright and the listing term will commence. If option 2, 3, or 4 is selected, then the listing term commences on the date of the execution of this agreement. Notice something is in bold, probably important. Seller may instruct the listing broker to change the status of status of property at any time. Remember, get that amendment, get that addendum. That is giving us permission to change the status. One of the other things that we need to include is the Bright MLS form called MLS Disclosures and Residential Seller Landlord Options. Remember, that always needs to be with your listing agreements. That's a Bright requirement. Now, again, we go into the next paragraph here in paragraph 6 to explain what public marketing is and non-public and limited marketing. So public marketing includes, but not limited to, showings, social media, flyers, yard signs, real estate websites, digital communications, emails, networking, or applications available to the general public. Another reminder, listings must be entered into Bright MLS within 2 days of the execution of agreement. Any sort of public marketing, the listing needs to be in the MLS. Now, the next part is non-public or limited marketing. Limited marketing is only, I'm jumping around here, only to the listing broker's network. So let's start from the beginning. Seller opts for property not to be publicly published in the MLS. Seller instructs listing broker to market only to the listing broker's network. Seller must sign Bright MLS form, seller instructions for limited marketing office exclusive at the same time they're signing the listing agreement. So if you are going office exclusive, there's a form for that, number 1. Number 2, you need the the regular Bright MLS form that the seller knows it is going as office exclusive. The next section here, status of property. Selection of status may be modified in the future utilizing the amendment to listing agreement change of status form. And on that form, it gives us a whole lot of options in which to change the stats. Excuse me. The next section here tells the seller exactly how we're marketing the property, and again, per seller instructions. So we might put it in a pre-marketing status, this first box. And what this means is property is not ready for public marketing and will be entered into Bright on a certain date when the listing term begins. So again, no formal listing until we're putting in the MLS on this date. Now, we might be doing a coming soon status. Remember, with coming soon, no showings. Coming soon status. It's shared on Bright MLS, but not ready for public showings and will remain in coming soon status until an expected on market date of whatever we put here. Property will automatically change to active status on this date unless seller instructs us to go on the market before then. So today is June 16th. Let's say the seller says, look, I'm not ready. I'm still painting. I'm still cleaning. I'm still decluttering. I'm still not ready, or I'm moving out, so it's vacant. And I won't be out till July 1st. We would put, say, July 1st on this date. But on, say, June 25th, the seller says, all right, I'm out. Let's go live. Then, again, per seller instructions, we can go live. Let's say we're down here on number 3, active status. We're ready to go. We're ready to go live today. Property's ready to go public marketing and share it in Bright MLS. Remember, 2 days. So today is Wednesday, the 17th. We list it today. We get our pictures tomorrow. We go live on Friday. And number 4 is that limited office exclusive status. Property is ready for limited marketing within the listing broker's network and is not marketed publicly. And seller must sign the seller instructions for limited marketing office exclusive form at the same time as the listing agreement. That's what I like to call the green sheet. It is a form. It has green boxes on it where the seller says, I understand we're going office exclusive. I understand the general public will not see it. And I understand I could be leaving money on the table. Any questions so far? All right. Paragraph number 7 is broker compensation. And again, this has changed over the last couple of years. Seller acknowledges that offers of compensation are negotiable, not prescribed by law or established by any membership organization in which the listing broker is affiliated. So nobody sets the commission. The Maryland Real Estate Commission does not set a standard commission. GCAAR does not set a standard commission. NAR, the MLS, does not set any sort of standard commission. Commissions are negotiable. Now, in the same token, you as the agent, us as the broker, we can have our own set commission structure. And again, commission is negotiable. So letter A, seller agrees listing broker shall receive a broker's compensation. And again, this is just the listing broker side of it. So let's say I'm charging 3%, I would put 3%. Or if I'm charging a dollar amount, I'm putting that dollar amount in here. And then notice the rest of the line. And an additional, sorry about that, and an additional flat fee in the amount of whatever. So if you are charging an additional flat fee of $350, that would go in that line. If you're charging $500, oops, wow, or $3,500, that would go in that line. Any sort of additional fee that you are charging would go in that line. Personally, I don't charge an extra fee, so it's blank. Seller acknowledges that the listing broker compensation will be earned and payable Number one, in the event seller enters into a sales contract during the listing period with any buyer procured by the seller, listing broker, sales associate, or other brokers or their associates, provided the buyer performs and settles on the contract. So you go under contract, you go to settlement, we're getting paid. Number two, the listing broker compensation shall be paid if property is sold, exchanged, or conveyed otherwise within blank days. This is what's known as the protection period. I'll just put 90 days here. After the expiration of the listing period or termination of this agreement, to anyone to whom property has been shown by listing broker or anyone else, including seller, during the listing period, unless a valid listing agreement is entered into during the term of said protection period by another licensed real estate broker. So what does this mean? I have 123 Magnolia Street listed, and we terminate, the seller terminates the agreement. Broker and seller agree to terminate the agreement, and they don't list with anybody else. And it's just sitting there for 90 days, or whatever number you put in this line. Somebody that looked at the property with me, or another agent that looked at the property with me, comes and buys it, we still get paid because we're within this protection period. Unless the property is listed by another broker or agent. So remember, this is the protection period. Number three, listing broker compensation due at settlement. And number four, should seller fail to perform or otherwise in default of the sales contract or execute a release of the sales contract to which listing broker is not a party, listing broker compensation is due no later than the agreed settlement date. So if the seller does not perform, or they get out of the contract, we still get paid. Letter B, additional listing compensation for unrepresented buyers. So we're seeing some of this, but not a whole lot. This is when a buyer shows up, you show the property, the buyer is unrepresented, they do not have an agent. This is where we can say we're charging the seller, say, an extra 2% of the sale price or an additional flat fee. And this is going to be, again, due at settlement. Paragraph C talks about buyer broker compensation. So the seller can pay a buyer broker a certain amount. Let's say 2%. We'll be generous. We'll say 3% of the sale price or a dollar amount. Reminder, payment due at settlement. And the seller understands that buyer broker compensation is negotiable and must be made a part of any ratified contract of sale. The seller can pay buyer's agents. They can agree to it here in the listing agreement. They don't have to. Generally, you're not going to see the sub-agent compensation. This is where we're paying a sub-agent, which means a buyer agent, but they're a representative of the listing brokerage, which again rarely happens. 99.9% of the time, you're leaving sub-agent blank. Paragraph E, forfeiture of deposit. If the earnest money deposit, or deposit as we're calling it, is forfeited, or there is an award of damages by a court or a compromise agreement between the seller and buyer, Listing broker may accept and seller agrees to pay the listing broker one half of the deposit in lieu of the broker's compensation. Provided listing broker's share of any forfeited deposit will not exceed the amount which would otherwise be due at settlement. So what does this mean? It's a whole lot of words. So let's say buyer defaults, the EMD is $10,000. Right here, the broker is seller is agreeing to pay the broker one half of the deposit. So $5,000 goes to the brokerage. Letter F, default by buyer. If seller enters into a contract with a buyer during the original listing period and the buyer subsequently defaults, then the original listing period is extended by the number of days property was under contract. So, your property is under contract for 10 days, your listing agreement extends 10 days. That's a unique thing on the GCAAR form. And letter G, attorney's fees. If listing broker prevails in any action to obtain payment of the listing broker compensation, listing broker will also be entitled to recover such, notice, reasonable attorney's fees and court costs. Not all, reasonable. Paragraph 8 talks about agency and the agency relationships we can have. So, again, because we're covering two states, we have to have a little chart here. Maryland and Washington, D.C. have adopted specific laws governing the disclosure of agency relationships and dual agency. A situation where the listing and selling brokers are associated with the same broker. Seller hereby gives consent for the listing broker, non-assigned agent, who holds their home open, to later represent a buyer in purchasing the seller's property or another property. All applicable jurisdictional agency disclosure forms have been made available to the seller who acknowledges the receipt of what's checked below. So, remember, in Maryland, there is no dual agency. You can only be a buyer agent or a seller agent. In the event there's a buyer agent and a seller agent in the same brokerage firm, that's called intracompany agent, because the broker is a dual agent and the broker needs to know what's going on under his umbrella between the buyer and seller agent. So in Maryland, we need to include the consent for dual agency. And if you're on a team, dual agency for a team. And if you're using this in Washington, D.C., they have a separate form called consent for dual representation designated representation in the District of Columbia. Now, if you're listing a property in Maryland, you would not select the DC box. If you're listing a property in DC, you would not check the Maryland boxes. Make sure you are checking the correct boxes. Paragraph 9 is authorizations. So seller is authorizing us to install a for sale sign on a property in accordance with applicable zoning ordinances and community association guidelines. Not every condo will allow signs. Not every HOA, etc. will allow signs, so we need to be very careful when we're putting a sign on. Paragraph B, you can see, is pretty long here, and we're talking about keys and lock boxes. So, Number one, use seller authorizes listing broker to allow key entry showings and the installation of a lockbox or key box, and the delivery of door access codes for use by Greater Capital Area Association of Realtors, GCAAR members, and members of current realtor associations, signatory to the electronic keybox service agreement. Again, these are the authorized users to access the property and to accompany, notice accompany, prospective buyers, inspectors, appraisers, exterminators, and other parties necessary for showings and inspecting the property. Affiliate or non-affiliate members, inspectors, appraisers, estimators, may have access for their business purpose if permission for a one-day showing code is granted below. So, again, a whole lot of words. Let's break it down. The seller is agreeing here that we can install a lockbox. We can give out the lockbox code to other realtor members, um, and to other realtor members. And the authorized users, generally people with the lockbox service, access to the property. And again, whoever is getting permission to access needs to accompany buyers, inspectors, appraisers, etc., for showing and inspecting the property. Now, some home inspectors, appraisers, etc., don't have access. And if the seller agrees to hear number two, we can grant them what's called a one-day showing code, so that between this time and this time, that there or for the day, really, for the day, this one-day showing code will allow them into the electronic lockbox. Also, some people use combo lockboxes. Nothing wrong with combos. Uh, just remember, somebody has the combo, anybody can get in. So let's talk about number two. Seller authorizes, and again, they're going to initial that they authorize or does not authorize one-day showing codes. It is understood by seller that there's a possibility that a person may use the access code in an unauthorized manner. Therefore, caution should be used with these codes, as such codes will allow certain individuals to access the property without an electronic record as to their identity. Seller recognizes that it is often desirable and advantageous to the seller and may expedite the sale of their property to have such access available. I've used this in the past. We've had to get a contractor in, um, and we gave them a one-day code. Or let's say there's an agent from Washington County, Maryland, that wants to show the property and they don't have access to the GCAAR lockbox. We can give them a one-day code in order to get in for the showing. We also need to tell the seller they're not one of the authorized users. Is the seller okay with that? And again, do they authorize it? So my theory is showing is better than no showing. Everyone's different. Number three, leased property. If property is under lease during the listing period, seller will furnish listing broker with a written authorization signed by all lessees authorizing the use of lockbox and keys. Generally, when I'm the listing agent and it's a rental property, um, I have a conversation with the seller and the tenants. Hey, tenants, when will you allow showings? Is it only going to be on certain days? Is it only during the daytime? Is it only at nighttime? So again, we're coordinating with tenants. Number four, private insurance. Seller is advised to take all precautions for safekeeping of valuables to maintain appropriate insurance through the seller's own insurance company. This is a conversation with the seller. Mr. Seller, Ms. Seller, put away your valuables, put them in the safe. Um, Medications, people go through medicine cabinets. So we want to put away our valuables. We want to make, and again, keep insurance on the property. And number five is liability. Seller agrees that any heirs and assigns shall indemnify, save, and hold harmless the listing broker, sellers, agents, affiliated brokers, salespeople, cooperating brokers, subagents, affiliate members with key and lockbox access, and other individuals who have used through one-day code by GCAAR from any and all claims or loss arising from the use of said keys or lockboxes, including listing broker negligence, breach of contract, or any wrongdoing exclusive of gross negligence or willful misconduct. Seller assumes any and all risks to damage, injury, except those caused by gross, negligent, or willful misconduct of any party. One of the things that I always explain to agents, this is not your home. And I explain that to listing agents, I explain that to buyer agents. It's someone else's home, it's someone else's possessions. Um, you're going into other people's private areas, bedrooms, bathrooms, etc. Um, do not do anything dumb, please. Paragraph 10. And I always see a lot of mistakes
Jonathan,
on paragraph 10. Yes, Simba.
good morning. How are you?
Good morning, I'm well.
Good. Sorry for jumping in so late.
That's okay.
Juggling some other things. When you just said that you let agents know that this is not your home, it
Mhm.
reminded me of during open houses when, because I insist people sign in. You cannot come in unless you sign in. And
Yes.
some will get upset and say, well, I went to another open house and nobody asked me to sign in. I said, well, that's not my problem. In this open house, you sign in because this is somebody else's house. It is not yours.
Yes.
We need to know
Exactly.
who you are.
Yep. Yep.
Uh-huh.
Um,
Yeah,
we can talk about open houses at a later date. I've got lots of open house stories. But you're exactly right. It's not your house.
exactly.
So, all right, paragraph 10, marketing and virtual office websites, also known as VOWs. So letter A goes into internet marketing. Certain features may be displayed on the website of multiple listing services, MLS, participants, including, and again, this is where a lot of mistakes are made. I see either everything checked and initialed or nothing checked and initialed. So, as the listing agent, you need to be very careful of what you're initialing and what each one says. Well, explain to the seller what needs to be done. So, number one, seller authorizes property to be displayed on the internet. More than likely, this is going to be a yes. And then the seller needs to initial. If the seller has selected no for this option, a consumer, where am I here? A consumer who conducts searches, sorry, I'm having issues here, conducts searches for listings on the internet will not see information about the property in response to their search. So only if they check no is the seller initialing on these lines. If yes is checked, the seller initials here. If they check no, then the seller initials there. The next part again gets confusing, and I've had to read it multiple times. Let me see if I can get it all on one page. There we go. If no was selected for option one, skip 2 to 4. So if no is checked here and it's initialed, we do not need to do any of these. If it is no, we don't select any of this. Now, if yes was selected for option one, then we do 2, 3, and 4. So yes is checked, then we do these. Okay. Seller authorizes the listing address, including house, unit number, street name, to be displayed on the internet. More than likely, you're checking yes. If no, if seller selected no, consumer who conducts searches for listings on the internet will not see the information. And then they initial here on these lines. So again, if it's yes, then we initial here. If they select no, then they initial here. Number 3, there's just initials for yes. Seller authorizes the display of automated estimates of market value. So that Z thing that we talk about. Again, yes or no. If it is yes, they're initialing. If it's no, there's no initials. I'm sorry. If there's no, you can also initial here too. And then number 4, seller authorizes the display of unedited comments or reviews of the property. We're selecting either yes or no, and we're initialing down here. Make sense? Again, only if no is selected for number 1, then they initial. If no is selected for number 2, they initial underneath the paragraph. But if it's yes, they initial just to the left of it on the lines. It's very confusing. Paragraph B, during the term of the agreement, seller by written request to broker may authorize listing broker to enable or display use of either feature described above. Listing broker agrees to promptly transmit the request to the MLS and cannot control if unauthorized or disabled features are displayed on the internet. Seller understands and agrees that public websites determine their own content and use of data, and therefore listing broker has no control over public website and no obligation to remove any content from a public website at any time. Listing brokers further authorized to and shall market the property through various means, including but not limited to for sale sign, photographing interior and exterior of the property, installing a lockbox. The seller also authorizes us to market the property, including the use of the address, interior and exterior photos in any media, which shall include but not limited to, at listing broker's discretion, otherwise limited by seller in paragraph 10A, which was the one above. Also, we need to explain to the seller that we're bound by laws, policies, and procedures and regulations in the MLS and the lockbox system. Seller hereby authorizes listing broker to report any contract of sale with sale price and terms into the MLS in accordance with the rules and policies. That's another conversation that we need to have um, with the seller, Mr. Seller, Ms. Seller, to let you know the sale price of your property will show up on the internet at some point. It's going more than likely it's going to be in public record. Uh, Bright will publish your sale price. It'll end up on all the websites. So just letting you know that up front. Paragraph 11 is inclusions exclusions. Unless otherwise negotiated in sales contract, the sales price shall include those items of personal property as described in the attached inclusions and exclusions disclosure. It is recommended that this disclosure be left at the property or placed online for prospective buyers. Just like we've discussed in Maryland, there's a separate form that goes over everything that's included or not included, and also goes over the utilities. Property condition and disclosure of material facts. Seller acknowledges, again, a legal requirement, that the listing broker has informed the seller of seller's obligations to provide a property condition disclosure to prospective buyers as defined in applicable jurisdictional forms attached hereto. Remember, in Maryland, you have the 3-page disclosure and 1-page disclaimer that you need to use. In DC, there's a 10-page seller's disclosure form that they fill out themselves. You do not fill that out. Paragraph B is the indemnification paragraph. Seller agrees to indemnify, save, hold listing broker and sales associates harmless from all claims, complaints, disputes, litigation, judgments, and attorney's fees rising from incorrect information supplied by the seller or from seller's failure to disclose material facts. So if the seller didn't disclose it and we don't know about it, it's the seller's issue. Paragraph C, hazardous material and conditions. There are environmental conditions and hazardous materials that could affect the property in the sale. Listing broker does not have the technical expertise to advise seller of their presence. Seller may employ an expert to inspect for the same. In the event that the seller conducts such tests and makes reports available to the listing broker, seller authorizes the listing broker to make those reports available to the buyer. So if the seller finds it out, they give us the information, we need to then disclose it. And amendments, seller agrees to amend in writing the applicable disclosures, etc. Moving on to paragraph 13, lead-based paint. If a property was built before 1978, it could have lead-based paint. Notice the wording here. Also, it is in bold. A seller who fails to give the required lead-based disclosure form, an EPA pamphlet entitled Protect Your Family from Lead in Your Home, may be liable under the Federal Residential Lead-Based Paint Hazard Reduction Act for 3 times the amount of damages and may be subject to both civil and criminal penalties. If it was built before 78, you need to use the form. Seller and agent involved in a transaction are required to retain a copy of the federal lead-based disclosure form for 3 years from the settlement date. Remember, if it's uploaded to command, it's going to be saved. So it needs to be there. The next paragraph here, property was built before 78, yes, no, or unknown. More than likely, you'll be able to tell from tax records if it was yes or no or unknown. Well, yes or no. Rarely are you going to see unknown. But if it's unknown, we need the GCAAR form, lead-based paint federal disclosure, and either lead-based paint DC disclosure or Maryland lead poisoning prevention disclosure also need to be completed. Lead-based paint is important to disclose. As we know, it can cause mental issues, physical issues. So before 78, have the form. Paragraph 14 goes into the renovation, repair, and painting of a property. This is called RRP, the Renovation, Repair, and Painting Rule by the EPA, effective in 2010. If the improvements on the property, house, outbuildings, etc., were built before 78, contractors engaged by seller to renovate, repair, paint property must be certified by the EPA, where such work will disturb more than 6 square feet of lead paint per room for interior projects and more than 20 square feet of lead-based paint for any exterior project, or includes window replacement or demolition. Before any covered work project, contractors must comply with all requirements of RRP. So it's important to make sure that the contractor has that EPA certification. Now, this next paragraph down here talks about sellers. A seller who personally performs covered work on a rental property is required to be certified by the EPA prior to performing such covered work. No certification is required. No certification is required for a seller who performs covered work on a seller's personal residence. However, the seller has the ultimate responsibility for the safety of seller's family or children while performing such covered work. If they want to know more, here is the website on renovation, repair, and the painting process. Remember, lead-based paint is important. Paragraph 15 goes on to encumbrances, liens, and other title matters. And this takes up the entire page here. Seller represents that no other person or entity owns any portion of the property or has any ownership rights to the property. So again, the seller's filling out well, all of the appropriate sellers are listed on the listing agreement, and those are the ones that need to sign. We're also saying seller has the legal capacity to convey clear title and warrants that the property is not subject to any right to purchase, lease, or acquisition by virtue of existing option, right of first refusal, or other agreement, meaning there's nothing that would impede them contractually from selling. There's no other sales contract on the property. Seller agrees that they may not negotiate new leases or extend leases during the listing period without written notification to broker. So if it's a rental property and they want to sell it and they're extending the lease, they got to let us know. Next paragraph, seller warrants clear title and agrees to provide sufficient cash to discharge at settlement all liens and encumbrances, including but not limited to existing deeds of trust, home equity loans, mechanics liens, deferred transportation related facilities charges and taxes, tax judgment liens, property taxes, co-op condo HOA fees, or any other unit specific unit assessments. Seller shall comply with all orders, requirements, notices, violations of any county or local authority, condo unit, owner association, homeowner, or property association actions in any court on account thereof against or affecting the property on the date of settlement. Basically, the seller is selling the property and they're agreeing that they're going to clear up any liens that are on the property. This is, I think, in every contract I've seen. Title is to be good and marketable and insurable by a licensed title insurance company with no additional risk premium. In case action is required to perfect a title, meaning to fix it, such action must be taken promptly by seller at seller's expense. Seller shall convey property by special warranty deed, which is the common deed used in Maryland and DC. And seller shall sign such affidavits, lien waivers, tax certification, and any documents as required by the lender, title insurance company, settlement agent, or government authority, and authorizes the settlement agent designated in the contract to obtain payoff or assumption information from any existing lender or lien holder. So the seller is giving the title company consent to order the payoff statements or assumption information, etc., and pay all of this off. Seller discloses to listing broker that the following are the only existing liens and encumbrances on a property, and existing matters could affect the title, and agrees to disclose any new liens or matters arising during the listing period. Now, when we're filling out the listing agreement, can check these boxes. If you want, when you put it in a signing envelope, you can make these optional that the seller needs to stop and fill them in. And again, filling in the balances here. This is again where we need to have conversations with our sellers. We need to do our homework and we need to check in public record through Bright MLS or maybe RPR if there are any liens. So, letter A, it is owned free and clear of any liens. Equity lines of credit. Please note a lien may still exist if there is a line of credit, even if the seller has no balance on the equity line. So a seller could have a $100,000 line of credit on the property, but they haven't used any of it. That still needs to be paid off. So if A is checked, you skip right down to G. Skip to G. There are no liens filed. I'm sorry, there are liens filed or secured against the property for federal, state, local income taxes, any unpaid property taxes, etc. Again, that's yes or no. I'm sorry. If there are liens, then this is checked. If there are judgments against the seller, that's checked. If the seller is filed for bankruptcy, that is checked. If it's an estate, if there is a deceased co-owner, we need the death certificate. So let's say it's a husband and wife and the husband died. The wife needs to get the death certificate. That's also a conversation we need to have as a listing agent when we see two names on the contract and only one person is there. If there's a pending divorce proceeding, we need to get a copy of the separation agreement to make sure that we can sell the property. If there are any other legal proceedings, and any seller is a foreign person, again, remember FERPTA. Let's say we have a seller that does have liens. So we would not fill out this first line. We would leave that blank. And then we would fill in B, maybe C, maybe D, maybe E if they're in default, maybe F if it's a short sale. So again, it's important to read if checked, and again, this first box. Letter, or well, this at the bottom here, during the term of the listing agreement, should any change occur with respect to the items, seller shall immediately give written notice to broker and listing agent of such changes. So the seller has a mortgage and they go into default, they need to let us know. Ownership and assessments. If it is part of a condo, a co-op, or an HOA, there's an addendum and it needs to be attached. And again, those boxes can be checked. Smoke detector and carbon monoxide detector. Sellers shall have smoke detectors and carbon monoxide detectors installed and operational in accordance with the requirements of the jurisdiction in which the property is located prior to settlement. Remember, there's an additional, not necessarily an additional form, but there's a disclosure form in Maryland talking about smoke detectors. It's a flyer that you can give your client. My recommendation, I get it initialed. Even though it talks about it in the listing agreement, I like to have it initialed by the seller. Fair housing laws. In compliance with fair housing regulations, shall seller property shall be made available to all persons without regard to race, color, religion, national origin, sex, physical or mental disability, or familial status. There are additional protected classes in DC and Maryland and some local jurisdictions. So, race, color, religion, national origin, sex, familial status, disability are the main ones. DC goes up to, I believe it's 23 protected classes. Maryland has an extra 5 protected classes. The one that I always have to slightly chuckle at is political affiliation. You can't discriminate based on political affiliation. That's DC. Number 19, seller acknowledges that buyer have the right to select the title insurance company, settlement, or escrow company, or title attorney. Seller agrees to pay settlement costs, including but not limited to release of liens or encumbrances against a property, deed prep, other legal document preparation, courier delivery charges, reasonable settlement fees, in addition to transfer and recordation taxes, and any other charge costs agreed upon in the sales contract. These are generally your standard settlement charges, so they will be here. Paragraph 20 is federal tax reporting withholding. We got to let the seller know that they're going to get a 1099. And the IRS requires the settlement agent to report the gross sales price, seller's federal tax ID, and other required information to the IRS. And the seller will provide this at the time of settlement. Paragraph B talks about FIRPTA, the Foreign Investment Real Property Tax Act withholding. If a seller is a foreign person for purposes of U.S. income tax taxation, the IRS requires that a percentage of a sales price be withheld from the seller's proceeds at the time of settlement. Those funds are applied towards the payment of any capital gains tax that might be due. A foreign person includes, and again, here it explains what that is, non-resident aliens, foreign corporations, foreign partnerships, foreign trusts, or foreign estates. Sellers are advised to seek legal or financial advice concerning these matters. If a seller is not a foreign person, seller shall execute an affidavit to this effect at settlement. Generally, the title company will help take care of all of this. We need to let the title company know. Yes, they are, or no, they are not a foreign person. Paragraph 21, general provisions. This is what I like to call standard boilerplate. Laws and regulations. Seller acknowledges listing broker must comply with federal, state, local laws and regulations, as well as licensing laws in DC and Maryland. Competing properties. Seller understands listing broker may have or obtain listings of other similar properties, and that their potential buyers may consider make offers on or purchase through the listing broker that are similar to the seller's property. Seller consents that listing broker representation of sellers and buyers on other similar properties before, during, and after the expiration of this contract. Let's say, for example, you are listing a condo in a building and the neighbor calls you and a neighbor upstairs calls you. You can list those properties also. And the seller understands that. And the seller knows that if, let's say, they're unit 2 and you also list unit 3, you can show unit 2 and 3 to the same buyer. Subsequent offer. Upon receipt by listing broker of a ratified sales contract pursuant to the listing agreement, broker shall have no further obligation hereunder to procure any additional offers. So property goes under contract. We do not need to keep looking for offers. Paragraph D goes over delivery. Delivery or delivered means hand carried, sent by overnight delivery service, sent by wired or electronic medium, which produces a tangible record of the transmission. Email, fax, such as fax email, which includes an attachment with an actual copy of the executed instrument being transmitted, or U.S. postal mailing, meaning we can use fax, email, or the post office to deliver documents. In the event of overnight delivery service, delivery will be deemed to have been made the next business day following the sending, unless earlier receipt is acknowledged in writing. In the event of U.S. postal mailing, delivery will be deemed to have been made on the third business day following the mailing, unless earlier acknowledged in writing. 99% of the time, we're doing it via email. And you can send your email up for read receipts. I always have a client email me and say received. Notice this agreement shall be deemed enforceable when it and all addenda and modifications hereto have been signed and initialed where required by seller and broker and delivered to the other party. Remember this last part, delivered to the other party. Paragraphs and headings are for reference and convenient and not define the or limit the intent, rights, or obligations of the parties. And singular shall include the plural, and the plural shall include the singular. A little bit of legalese there for you. Paragraph 22, authority to disclose existing offers. This, I think, is a fairly important one. Seller is advised that prospective buyers or cooperating brokers may inquire of the listing broker or listing broker's agents the existence of other offers to purchase the property. Disclosure of other offers could result in the buyer making their highest and best as promptly as possible, or could result in them electing not to make an offer. I've had situations where a buyer knows there's multiple offers and they don't make an offer. And I've also had a situation where buyers go above and beyond the sale price. It's important here that the seller authorizes or does not authorize the listing broker to disclose the existence of offers on the property in response to inquiries from buyers or cooperating brokers. Such disclosure may include the source of offer, if it's my offer as the listing agent, or somebody in my firm, or a competing broker. Generally, I'm going to say seller authorizes because it, again, generally doesn't hurt the seller. That's a conversation to have with your seller. Paragraph 23, the seller does or does not elect to purchase a home warranty. And if they do, cost not to exceed a home warranty provider. Again, we put there. Paragraph 24, it is a binding agreement between seller and listing broker. Between seller and listing broker and cannot be changed except with the written consent of all parties. Any prior discussion between the parties concerning the subject matter is superseded by this agreement. Get any changes in writing. This agreement shall survive execution and delivery of the deed and shall not be merged herein. Meaning that this agreement stands through the execution of the deed. If the agreement is signed by more than one person, it shall constitute the joint and several obligations of each party. Therefore, it's binding upon the parties, their representative successors, heirs, and assigns. The agreement will be interpreted and construed in accordance with the laws of the jurisdiction. So if it's in Maryland, we're following Maryland law. If it's in DC, we're following DC law. Seller hereby acknowledges that seller read and understood the agreement, and they may seek legal advice prior to signing it and acknowledge that all information provided to the listing broker and seller by seller is true and correct, and to the best of the seller's knowledge. Seller hereby acknowledges a receipt of the copy of this legally binding agreement and agrees to be bound by its terms and conditions. Remember, it needs to be signed by all parties. For termination, again, it's a little bit different. This agreement may be terminated prior to the end of the listing period only by mutual written agreement of the parties. This is for DC. And if you're in Montgomery County, there's an additional addendum to the listing agreement. More than likely, you're not adding any additional terms here on this line. And then at the bottom, it is signed by the seller. There's multiple sellers. Again, they're signing. There might be two of them. The listing broker is signing it. And then you, the licensee, are also signing it. Notice my name auto-populated here as the listing licensee. One quick note here at the bottom. If any party is signing for another fiduciary, we might need the appropriate power of attorney or administration letter or other authorizations. And again, an original document is required for settlement. So if there's a power of attorney, we need the original to be brought to settlement. The settlement company will generally ask in advance for a copy so they know. And again, that might also change the name of the seller. Let's say it's Joe Smith and Frank Smith is Joe's power of attorney because he's his brother. It would say Joe Smith, comma, POA, Frank Smith. And this is the end of your GCAAR listing agreement. Remember, this listing agreement is for real property and co-ops in Montgomery County and Washington, D.C.